Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Virginia and Texas. It is April the 25th of 2023, and this is your legal news roundup, all of the goings on in your legal world so you can be better legally informed. We begin with a story about Ford winning an appeal that's going to save them a lot of money. Ford has won a lawsuit that was going to cost them potentially $1.2 billion related to claims on fuel efficiency numbers. So this may sound vaguely familiar. Volkswagen, of course, somewhat famously got into a lot of trouble a couple years ago on fuel efficiency claims. And maybe other places or other companies are also playing fast and loose with their fuel efficiency numbers. But Ford has won its appeal, so it doesn't have to pay this money. Ford was accused of deceiving the EPA and inflating their MPG ratings by as much as 15%, which that sounds concerning. All right, so let's learn a little bit more. Ford has defeated an appeal, or yeah, Ford has defeated an appeal in a case that accused it of deceiving the EPA of inflating MPG numbers of pickup trucks. The court ruled that agency authority is greater than individual state authority in determining fuel economy. So the underlying legal issue here is preemption. Preemption. The federal government has regulations when it comes to cars, including fuel efficiency. States have regulations on cars, including, apparently, fuel efficiency. So, what happens when you have a potential conflict between these two things? And one of the ways that you resolve that legally is through the idea of preemption. If the federal government speaks sufficiently clearly, then the federal government's regulations will govern because it's interstate commerce. And we all know how that works. The federal government regulating interstate commerce. So it has to do so clearly, it has to do so directly, but if it does so, then it can overtake state level authority on these issues. So in trying to determine what the right MPG numbers are, or how to calculate the MPG numbers, the correct methodology is the one set out by the federal government, right? There could be other methods of calculating MPG. How do you go about calculating it? And so you, depending on how you calculate it, you might come up with different numbers. But the correct way to do it is the federal system. That's what this lawsuit is about. Whose procedure governs? And in this situation, the federal government's does. So the state one can take a back seat. The Sixth Circuit ruled against a class action plaintiffs who claimed that the automaker had misled the Environmental Protection Agency by intentionally miscalculating factors used to certify the numbers. The plaintiffs had claimed that this led to the EPA overestimating fuel economy by as much as 15%, which of course would potentially induce them to pay more for the truck, and of course would definitely induce them to pay more for fuel. So you can't mislead the consumer. You have to have honesty in your trade. So the number has to be accurate. But accurate based on what? Based on the way the federal government wants you to calculate it. The court found that federal law gives EPA authority to estimate the economy, which preempts the field. That's the relevant issue. Preempt is the magic word in this paragraph. That is your legal doctrine. The circuit judge added that the estimates do not need to be strictly accurate because, of course, they're estimates, and the agency has significant authority to investigate and combat fraud. So, are the numbers perfect? I don't know. Are the numbers calculated the way the EPA wants you to calculate them? If so, then you've obeyed the law. So maybe the EPA should have a different method, or maybe they should require greater precision. I don't know. Talk to the EPA about it. But as far as Ford's concerned, apparently they did what the EPA wanted them to do. So, that's that. And the state over here is like, we want you to do it a different way. No, not so much. So state law tort claims like plaintiffs would skew this and permit jurors to take the EPA's place. So no, not so much with that. Ford said it was pleased with the results, which followed an investigation from the Justice Department into emissions and fuel certification. The probe closed in 2021 and no legal action. So either Ford was complying or it was not a big enough deal or whatever. But the Justice Department apparently looked into this issue. And as far as they're concerned, they're happy. So apparently Ford did what they were supposed to do as far as the federal government's concerned. And the states over here, like, hey, we want you to do it a different way. And the federal government's like, oh, nah. The plaintiffs are unhappy, say this is a horrible result for consumers, says it's dead against Supreme Court precedent that allows state to regulate deceptive conduct. Yes, states have authority to regulate deceptive conduct in generally. Honesty in trade, honesty in business, honesty in advertisement. Yes, states have broad authority to regulate advertisements, representations in trade. They sure do. In this particular context, however, in this particular context of the EPA thing, the EPA has preempted the field. So yes, states have lots of general authority, just not here, because the federal government has preempted the field in order to have a nationwide standard. And the virtue of having a nationwide standard is that no state can come on top of it. So regulate trade in some other way, but not this. Thus, that brings us to the end of the case of the Ford F-150 and Ranger and fuel economy. Apparently, there was some concern that the EPA numbers might not be accurate when it comes to the miles per gallon. How many miles per gallon is this car getting? Not many, I'm sure. But whatever the number was, it was off. Or so said the people complaining. The federal government looked into it and like, yeah, we're good. And the states are over here like, we have authority to regulate honesty in trade. Yes, typically you do. But the issue is, how is that number accurate? What is the accuracy of the number? When they say MPG and they put it on the thing, how do we determine if it's accurate? The federal government says use this formula. So the number is accurate. It is accurate. There are other ways to potentially generate the number. You could potentially require a more precise number or a different, thresholds of tolerances or something. But the federal government's like, well, this is the accurate number. And so the states are over here like, it's inaccurate. No, it's not. So it's not dishonest. So you can't regulate it, state. And that, for the moment, brings us to the end of discussion of this case. Good morning, everyone. Good morning, everyone. Welcome to Uncivil Law, where, as always, we learn through that misfortunes of others. I am so happy you are with me here today on this beautiful Tuesday morning, and I love all of you, and you are just the best. Boosh McFadden with the first comment today saying they couldn't stay, but just wanted to say that I'm awesome. Hope I see this. I saw it, Boosh. I saw it. It warmed my heart. Thank you, Tina, Tammy. Thank you, Rick, Eric, Baby, Meatball, Catherine, Jen, Hera, Rachel, Betsy. Good morning with the nice little flower. I like the flower. I approve. Dark King Astris, B. Davis, Sarah, Sandra. A Capitan is here, as always. Good morning. MJ is here. Chris, Forbidden Ruin is here. Wendy, Jerry, Laws Unicorn, Catherine, C.A. Agenda. Glad to have you here. Will I be talking about the Idaho 4? Well, there's not much to talk about. The judge issued or is maintaining the gag order, so not a lot to talk about right now. So, but yeah. Girl Scout was here. Sandra's here. Patty. Is Biden officially announced he's running for president? Well, that's good news, I guess. Glad you are all here. It's a beautiful day in Austin. I had a very nice improv class last night. They threw a lot at us last night in improv class, a lot of stuff. And so it was a little bit hard to get it all internally. But then I had a very nice night out afterwards with one of my people, just chatting. It was nice. So, good times. All right. This one is a little bit more for me. This one's a little bit more for me today. The U.S. Supreme Court has rejected a request for certiorari from a guy who is, in my opinion, a complete and total pain in the ass. This guy is a treat in not a good way. This guy really thinks that the AI should be allowed to be inventors and authors. And yeah. So unsurprisingly, the U.S. Supreme Court has refused to hear this challenge. Stephen Thaler. If you don't know that name, I don't blame you. There's no particular reason you should know that name, but his name is spoken with dark whispers and hushed whispers in patent law land. The patent lawyers know who Stephen Thaler is. And the copyright lawyers probably know who he is too, because he's also petitioned the Copyright Office for AI generated work to have the robots listed as authors. And he filed an application for an invention claiming the machine itself did the invention. And the patent office is like, no. And the Court of Appeals for the Federal Circuit said no. And the US Supreme Court said, go away. And in copyright world, it's not going much better. The Copyright Office has said no to the same guy. And I'm sure he'll appeal, and the Supreme Court will eventually say no to him too. I don't know why he has a bug up his ass, but he definitely has a serious bug up his ass because he's been doing this kind of thing for a while. So he got dissed by the US Supreme Court. So this one's more for me, just mocking this guy because I don't know why he's such a bug up his ass, but he does. And just like, oh yeah, the machines should be inventors. The machines are authors. So yeah, this guy is a treat. So Thaler founded Imagination Engine, an advanced artificial neural network company. According to Thaler, his system created a unique prototype for a beverage holder and emergency light beacon entirely on their own. And the patent office said no. If it's entirely on the machine's own, then no. The Court of Appeals for the Federal Circuit said no. And the US Supreme Court said go away. So that one's more for me. So Thaler continuing to lose as he has many times before. And that brings us to the end of the discussion of this story. Thank you for the gift memberships, Jules Buddha. That's very, very kind. We do appreciate everyone who helps to support the channel. Yeah. We appreciate everyone who helps support the channel with gift memberships. We like everyone who sends super chats. We enjoy everyone who is a member themselves. All right. The appeal from Epic Games against Apple has come to a somewhat predictable end, as the appeal court has ruled that Apple can maintain control of its App Store. There was a question dealing with this as it relates to an improper monopoly, improper restraint of trade, improper tying, that Apple has improperly gained a monopoly with respect to the App Store itself, because the only way to use an app on an iPhone is to buy it through the App Store. And of course, Apple gets a cut of all those things. So very, very good for Apple. And Epic Games over here had a problem with that and sued. So the appeal court has just ruled that Apple can maintain control of its system and exclusive control over distribution of its apps. The 92-page decision issued by the Ninth Circuit Court of Appeals affirms the findings of the lower court judge who presided over the 2021 trial that resolved around antitrust lawsuit by Epic Games. That's the improper time, improper monopoly, improper restraint of trade, antitrust. The Epic Game lawsuit alleged that the App Store, which was launched in 2008, had turned into an illegal monopoly that stifled innovation. Epic tried to offer an alternative way to get at its app, attempting to evade developer fees, which are 15 to 30% depending on how much product you're selling. Apple charges a different rate. I think it's for the first $1 million of sales to help encourage smaller developers, and then a larger rate after the first $1 million sale. So it's a progressive tax system, right? We'll charge you one fee on your first $1 million, and then we'll get a different fee for every dollar after that. So, okay. Apple, of course, for its part, ousted Epic from its App Store for violating the App Store guidelines. It's like you tried to get around it and you violated our store rules, so we're going to kick you out of the store. Apple said the restrictions were in place to help protect security and privacy and also help to recoup some investment in the phone. Some of that's probably fair. Some of that's probably we just like money. But, if they did allow side loading as an official policy, if they allowed other app stores to load things that were outside Apple's control, then that presumably would increase the risk exposure to Apple. So how good of a job do they do cleaning and vetting their own app store? But whatever job that is, obviously, if they had no control over it all, that would present an additional vector that Apple would have to secure against. So Apple has decided to take a much more walled garden approach on the whole thing. The U.S. District Judge, of course, had rejected the claims of an improper monopoly that had been levied against Apple following a 16-day trial. That trial featured more than 500 exhibits and testimony from CEO Tim Cook and Epic's CEO Tim Sweeney. The appeals decision backed the district court's decision that Apple's store was not violating federal antitrust law, and Epic hadn't proven that consumers didn't have freedom to switch to other alternatives, such as phones powered by Android. So, not improperly restricting trade, because people can choose alternatives, and people do choose alternatives. Lots of people choose the Android, particularly in other countries of the world. So, if you like Apple's system, then Apple. If you want a more free reign environment, then Android. So yeah, users who place a premium on lower prices by purchasing Android can select one of several open transaction platforms, which provide less security and privacy because they're not being vetted by their nature. So it's more free for all, like a computer. And given how much data is on people's phones, and how much of a problem that can be if your phone is compromised, it's not an illegitimate concern. So, especially as people use phones even more than they do typical computers and use them more and more for transactions and monetary transactions. So, wanting to make sure the phone is secure is a reasonable concern. It's Triton says this article completely misses the point. Does it? Okay. Epic is pursuing an antitrust lawsuit against Google and its Play Store as well. That lawsuit is still ongoing. Another section of the decision backed Apple's assertion that one of the reasons people decide to purchase iPhones stems from the security and privacy. So the very walled garden that these people think is a problem is the very reason, at least in part, induces some people to purchase iPhones, which I think is probably true. It was an in-game purchases issue. It doesn't matter. The underlying legal theory doesn't matter, I should say. It wouldn't matter as to the legal theory, to be fair. It wouldn't, I don't think it would make a difference as to the legal theory. So either Apple has complete control over the apps and what those apps do, or it doesn't. And so you want to be able to purchase things. So I'm not sure it necessarily impacts the underlying legal issue in a way that makes a difference, but okay. In a tweet, Epic's CEO affirmed the Apple appeal court triumph and then followed up with another tweet saying the company is working on next steps without elaborating, which I imagine will be begging Apple to come back, since at the moment they can't come back and the court's not going to force them. Monday's Ninth Circuit decision wasn't necessarily an across-the-board victory for Apple, so there might be an additional appeal at some point. In the lower court ruling, the district judge affirmed a section of lower court that some Apple store rules constitute unfair competition. Those so-called anti-steering violations stem from Apple prohibitions preventing promotions of payment options from inside the apps. As a remedy, the judge had ordered Apple to allow developers throughout the US to insert links to other payment options besides its own. That change would make it easier for app developers to avoid paying Apple some commissions. Apple had appealed that part of the decision, but was rebuffed. In a statement, Apple saying whether to contest that finding further. So perhaps they will be able to provide links from in-app that allow payments that will not have to go through the app. So that part looks like it might remain intact. We'll see. Thus, that brings us to the end of the discussion for the moment about Apple's near total win as it relates to the App Store, but with some potential wrinkles for Apple. Based on the decision of the Ninth Circuit, it looks like Apple might have to allow app developers to provide some links within app that would allow people to pay for things outside the app, so that would not go through Apple. So Apple wouldn't take a cut. So that is an interesting part of the ruling. So will that remain intact? Will that need further review? How will Apple deal with that? We will see. But at least for the moment, that brings us to the end of discussion of this story. Didn't car manufacturers get in trouble for requiring particular oils to be used to avoid warranty? Yes, they sure did. It's a violation of the Moss-Morgan Warranty Act, federal law. So yeah, they can't do that. Well, unless it's actually truly necessary, and they have to prove that, which is a whole other thing. But yeah. Dun, 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 dun. Dun, 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 dun. Apple isn't the only brand of phone. You can always buy a Samsung, Google, or BlackBerry. If you can buy a BlackBerry, let me know. Good times. Trigger warning. Hello, Patricia, composer, Nancy, all kinds of good stuff. All right. I really enjoy my AM Roundup. You've really found our niche. Well, thank you. I think it's been working out pretty well, the AM Roundup. People seem to enjoy it, producing some reasonably good results for the channel. Nice. What's up next on Cooking with Kurt? I don't know. When I finish eating the chili, I'll let you know. Loving the morning session. Thank you very much. All right. Ed Sheeran is involved in a copyright lawsuit relating to the works of Marvin Gaye. And that lawsuit is coming to a head in the trial court. So we're going to learn a little bit more about this copyright lawsuit against Ed Sheeran and some of the legal issues that are involved. Let's get started with this. Ed Sheeran's much-awaited copyright trial starts this week in Manhattan. Sheeran stands accused of copying Marvin Gaye's legendary song "Let's Get It On" in his song "Thinking Out Loud." So apparently, in "Thinking Out Loud," we have improperly copied "Let's Get It On." Okay. This lawsuit, filed by the heirs of the song's co-writer and composer, claims Sheeran unlawfully employed the heart of the song. That is, the harmonic progressions and melodic and rhythmic elements. Okay. Yeah. This suit claims Sheeran copied those elements and repeated it continuously throughout his song, Thinking. This uncontrovertible musical similarity has been observed by music industry professionals previously, as embodied by various social media and articles about the matter. Sheeran has denied the suit since it was filed. For his part, Sheeran has insisted in his court papers that the heart of "Let's Get It On" is composed no more of routine elements of popular songs that aren't unique, original, or protectable. So, yeah. So we got into this idea about, did we take elements and are those elements protectable? So that's fun. And this definitely has echoes of some previous lawsuits that we've seen in this domain, like Katy Perry with that whole lawsuit as well. Very similar ideas. It's like, okay, is this simply individual elements that are not protectable, or is it protectable elements? What is the boundary lines here? So, okay. Sheeran is accused of copying musical building blocks of the song, not the lyrics or overall field. So I don't even know what that means, really, from a copyright perspective, to be honest. So not copying the lyrics, I mean, okay, the lyrics have a separate copyright because that's written as opposed to music, right? So the lyrics are separate. So not copying the lyrics, I understand. But the musical building blocks, I mean, as opposed to what? Because songs are written for musical building blocks. So the jury's supposed to weigh only whether Sheeran copied those blocks, which were recorded on sheet music. So is this sheet music look similar to this other sheet music? I guess. Townsend's family has been vocal about the case. "This must stop," the daughter said. "We have enough chaos going in our world today, besides having to stand here and worry about people stealing other people's belongings." Wow. The article also quotes Ben Crump, who managed to squeeze his way into this story somehow, which is hilarious. The civil rights attorney who's representing Townsend's family, as saying "Thinking Out Loud" exemplifies the history of appropriation. Well, I instantly hate their claim even more than I did when I started, because it's Ben Crump. And Ben Crump, anything he says, I pretty much universally disagree with. Because Ben Crump. Because he is he takes the racism issues. He finds racism everywhere. And he definitely is not afraid to litigate over the racism in apparently all the things. Ben Crump, wow. For far too long, black artists have created, inspired, and spread music all around the world. And Ed Townsend's family believes artists like Sheeran's infringement of black artists is merely another example of artists exploiting the genius and work of black singers and songwriters. Yeah, that sounds like something Ben Crump would say. Yeah. Sheeran also faces two other lawsuits in the same courthouse over similarities between "Thinking Out Loud" and Let's Get It On." Those lawsuits were filed by a company that holds an 11% stake in the "Let's Get It On" song. In 2016, two songwriters behind "Amazing," a song performed by Matt Cardiel, filed suit against Sheeran, alleging he had claimed copied aspects of the track for "Photograph." This case was settled in 2017. with the writers getting credit. So fine. The legal team representing Sheeran has insisted the two songs are structurally similar only because pop music is characterized by similar elements. The two songs share versions of similar and unprotectable chord progressions. So that's. Thus, that brings us to the end of the discussion of this lawsuit over Ed Sheeran's work. Apparently, he ripped off Let's Get It On or something. I don't know. And so, good times. And that, for the moment, brings us to the end of this discussion. And I see I'm being criticized in chat right now. So, yeah. Let's see. All right. Yeah, Pharrell Williams. Yeah, exactly. Yeah. That was a bullshit lawsuit, in my opinion. Disagreed with the Ninth Circuit big time on that one. In Breonna Taylor news, the cop who shot Breonna Taylor, which caused much consternation in the nation, is been hired in a new job in law enforcement. The cop who shot Breonna Taylor has gotten a new job. I'm sure this will thrill everyone who followed the story for so long. So let's learn a little bit more about Breonna Taylor's cop and his new job. Let's learn more. The former Louisville Metro Police Department officer who fired the shot that killed Breonna Taylor more than 3 years ago has a job now at a sheriff's office in nearby Carroll County. Miles Cosgrove was one of 3 officers who opened fire during the raid at the apartment during the no-knock warrant search that was issued in connection with an investigation into Taylor's ex-boyfriend. Taylor was shot and killed 2 months before George Floyd was murdered in Minneapolis, so part of that cultural news cycle. Public outcry over the 2 cases, along with the death of Ahmaud Arbery, led to nationwide Black Lives Matter protests that were happening during COVID. The police killing of Taylor eventually resulted in still pending federal charges against a number of detectives and other individuals involved in the death. The U.S. Department of Justice's case alleges that civil rights offenses, unlawful conspiracies, unconstitutional use of force, and obstruction, including falsification of search warrant, that resulted in Miss Taylor's death. And yeah, we covered that a little bit. There does seem to be some evidence that would lend you to that conclusion. Now, who knew about that in the police department at the time the search warrant was executed is a whole nother set of problems, right? But that there is some evidence that suggests that the police or elements within the police department knew that the warrant was based on crap and even fabricated it. And so that might have led to this, right? So the Justice Department is looking into that allegation, and there's some evidence that suspects that might be true. So some people within the police department might have some sort of exposure because if they knowingly, purposely falsified an affidavit to get a search warrant, that violates someone's civil rights. So, go figure out if that's true and go prosecute those people. That'd be fine. That is not something that should happen. The U.S. government has alleged that Miss Taylor's Fourth Amendment rights were violated when defendants Joshua James, Kyle Meany, and Kelly Goodlott sought a warrant to search Miss Taylor's home knowing they lacked probable cause. That's the key. They knew they didn't have it. They knew it was crap. The DOJ has alleged the defendants knew The affidavit in support of the warrant contained false, misleading information and omitted material information. And so, therefore, the warrant was invalid, and therefore they deprived her of civil rights, her Fourth Amendment rights, and therefore that violates federal law. So 3 of these officers are suspected of exactly doing that. And if that's true, then go to jail. Don't violate people's constitutional rights. That's a bad thing to do. The Attorney General has said that it was not true, that certain officers who worked on the warrant knew it was not true, that they had verified the target of the drug trafficking probe. Cosgrove was never charged, either locally or federally, but in 2020, the police department sent him a pre-termination letter saying he violated policy when he appeared to fire 16 shots after not clearly identifying the target. And there was some evidence of that too, that he was firing blindly and posed a threat to unknown people and behaving in a potentially reckless way. So, yeah, there's some evidence that happened. So, that he violated policy by doing that, yeah. The police department said it was a violation of policy when Cosgrove used deadly force and did not properly evaluate the threat or identify target beyond flashes. I see this distorted, shadowy mask, this figurine, this figure in front of me that's just, it's coming and going due to flashing lights, Cosgrove was quoted. Not super encouraging when we're firing rounds. We're firing them at shadows. Not great. Chief Deputy Rob Miller of the Carroll County Sheriff's Office has reportedly confirmed Cosgrove has been hired and acknowledged the decision might be polarizing to some people. Yeah, I mean, he's a guy who appears to not have the greatest discipline when it comes to firing and recognizing and observing the targets, posing threats to all kinds of people unknown, shadows, including potentially other officers who might be in the room at the time. So, yeah, there's some controversy there. But the chief deputy of Carroll County has suggested Cosgrove's law enforcement experience was potentially valuable to the small department. We're going to give him a chance. Okay. So protests, of course, unsurprisingly, are being planned. Thus, that brings us to the end of the discussion about Miles Cosgrove, who was the person who shot Breonna Taylor, who is now gotten a new job as a sheriff in a nearby town. He was dismissed from Louisville Police Department for violation of policy in relation to what would you say? He was fired from the Louisville Police Department in relation to improper use of firearm by not recognizing his target and what's behind it. But apparently the sheriff's office feels like, he's learned his lesson and willing to give him another shot. So Miles Cosgrove goes on in this world to become a police officer again. And that, for the moment, brings us to the end of the discussion of this story. All right, so let's see. Let's skip that story. Let's do sad story, and then we'll do Florida man. For the 227 of you who are currently here, thank you very much. Did you see Bronco's analysis? I'm sure I did at some point. I've done my own analysis of the shooting as well. But maybe I didn't see something in particular. But, although to be fair, I do disagree with Bronco sometimes. So we might have a divergent opinion, but that's okay. We're allowed to have divergent opinions. You should listen to a wide range of people and become better informed about how different people think about such things. Plus, I could be wrong. Plus, he could be wrong. So, good times had by all. Reasonable minds can sometimes differ. That's true. Yeah. I remember when Bronca and I got into it a little bit on the guy who showed up in Texas with that custody dispute, with like the child custody dispute, and wound up getting killed. And the guy had the rifle and stuff in his home. And Bronca and I had a different disagreement on the issue, where I thought, it's a just shoot. And Bronca's like, well, the exact moment he pulled the trigger, there wasn't a threat. I'm like, yeah, but there was half a second earlier. You're slicing time kind of thin, Bronca. Like, oh no. So yeah, sometimes we disagree. That's okay. Man. All right. A therapeutic boarding school in Utah told a vomiting team to suck it up before the infection that was causing her to throw up killed her from sepsis. So the boarding school looked at this sick vomiting teen, said, suck it up, but actually sepsis. So great. Good job. Good job handling that situation. All right. The 17-year-old girl died last December at a school for troubled teens in Utah after experiencing extreme pain for a treatable infection, according to the autopsy. The revelation that Taylor Goodrich had the disease shows that the daughter's death was entirely preventable and would be alive today if she had received treatment that she had begged for at the time. So apparently, this girl had been sick for quite some time, and the school appeared to not care. And so, yeah. The autopsy's result emerged as parents continue their lawsuit against Diamond Ranch Academy on claims of false imprisonment, premise liability, innkeeper liability, child abuse, negligence, and reckless indifference, and breach of fiduciary duty. All those things sound plausible. In the complaint filed in 2022, Taylor Goodrich was identified as Washington State resident staying at the boarding school in Utah. Diamond Ranch Academy filed a motion to dismiss just a month after the plaintiff filed. Family amended the complaint to add John Doe as a defendant. A proposed second amended complaint specifies that John Doe defendant is Big Springs Property, the owner of the property, which makes sense. Sue the school, sue the landowner, sue everyone in sight is typically how you do this, right? Diamond Ranch Academy promises parents that students will be able to ensure their basic health needs, such as requesting appointments, addressing medical concerns, and medical staff would tender their needs on site as if they were family medical practice. Given these representations, the plaintiff's minor daughter was matriculated into the program, removed from her home, and physically placed in the program where she was a resident for several months. Unbeknownst to plaintiffs, and despite the assurances, representations, and promises, children that become ill are often ignored or told that they're faking their illnesses. Many claim they're given aspirin and water and told to suck it up. So, yeah. If you are a guardian, in fact, for a child, right, like at a school, like a boarding school, that gives you certain positive obligations, unsurprisingly. So if you are caring for a child, 17-year-old or not, you know, telling them to suck it up. If that's part of a pattern of conduct and part of a general pattern of showing active disregard, you're going to have a problem. So Academy over here looking like things are going not great. Litigation says that Taylor herself was specifically told, suck it up. The plaintiffs allege that their volleyball athlete and cheerleading daughter began to experience pain in December. On December 6th, Taylor's scheduled Zoom call with her parents was canceled based upon behavioral issues. A week later, Taylor was vomiting, and this apparently continued for days. So, yeah, I would think at some point you would be a little bit more concerned about it. The pain apparently became so excruciating that Taylor was begging the staff for help. At one time, Taylor collapsed into her own vomit. So, things are going great over here at the Diamond Academy. The next day, apparently, Taylor died, or apologized. The day that Taylor died, she allegedly was forced to shower and go to breakfast rather than be given emergency medical attention. The school called the father and told him that Taylor had suffered a heart attack. The school then called the father and told him that she had perished in the hospital from the heart attack. Yeah. The plaintiffs claimed Diamond Ranch Academy false imprisonment directly led to severe physical pain, discomfort, loss of enjoyment of life, and death. The U.S. magistrate judge ordered the Second Amendment complaint filed within 14 days. Defendant's motion to dismiss, this should be good, argued that the plaintiff complaint lacked subject matter jurisdiction. Oh, okay. And multiple alleged counts failed to state a claim. Particularly, defendants say the lawsuit improperly commenced before plaintiffs filed claims under Utah Health Care Malpractice Act to a non-binding pre-litigation hearing through the Division of Professional Licensing. What? I don't know anything about Utah specific law, but that sounds like some bullshit. But okay, maybe there's some sort of process they have to go through other than suing. All right. Goodridge has yet to participate in this non-binding pre-litigation hearing. If it's non-binding, why does it matter? And thus, the court presently lacks subject matter. Accordingly, they should dismiss, or on the alternative, stay until they've completed the pre-litigation. It's non-binding. So what does it matter? It's just a formality for the sake of formality at this point, right? It's like it doesn't matter what happens because it's non-binding. It's like, I'm just going to go to lawsuit anyway. The underlying facts giving rise to the claim clearly demonstrate the subject litigation is wrongful death arising from medical malpractice. No, I don't think that's really necessarily the underlying claim. I'm not sure the underlying claim is medical malpractice. That's definitely one way to phrase it, but medical malpractice, not necessarily. The school isn't a doctor or a hospital. The owner of the property isn't a doctor or a hospital. Some of them might be nurses, but that it's medical malpractice, that's not inherently obvious. Despite this, they've creatively asserted multiple causes of action that are not cognizable or do not appear to apply to the facts. Okay. The aforementioned Second Amendment complaint noted that plaintiffs are in fact in the process of complying with Utah Code in order to bring in action pursuant to the Malpractice Act, and the complaint will be amended once that process is complete with. Plaintiff responded, this is not so much a medical malpractice case. Yeah, I don't really, but a case where there's no medical aid rendered at all. And also some of these people are not doctors, presumably. And so medical malpractice doesn't seem like necessarily the correct cause of action here. So, all right. The Utah Department of Health has noted the institution currently has a conditional license, meaning the provider is at risk of losing their license because it has not complied with licensing rules. Apparently, the provider was out of compliance by failing to provide and seek necessary medical care for an ill client. During on and off inspections, investigators concluded multiple interviews and reviewed program documentation. This information substantiated The provider was aware the client was ill and did not take them to an emergency room. So the Utah Department of Public Health seems to think that there was some deficiencies along the way as well. Yeah. Thus, that brings us to the end of the story of Taylor Goodridge, unfortunately, who died as a result of apparently massive neglect because she was apparently sick, ill, and vomiting for days and did not get medical care from the people that were in charge of her, her guardians, in fact, who, as you would expect, have some obligations to her in that role. The family sued, and apparently they have to comply with some non binding blah, blah, whatever. So they're in the process of trying to figure that out. And I think that in the end, if all this is proven, I think the school is in a fair amount of trouble. And that, for the moment, brings us to the end of the discussion of this story. And a fly in the sky, I can do just as high. Sandra Ramirez gifts 5 memberships. Sandra Ramirez is a good person, gifting memberships to other people, the other uncivilians, so they too can enjoy the joy that is being an uncivilian. We appreciate all of our uncivilians, and we appreciate everyone who gifts memberships because they help the channel grow. You are awesome. Thank you, Lucy. I appreciate that. That's very nice of you. All right. Let's turn our attention to Florida Man and wrap up today's stream. For today's Florida Man, we turn our attention to a law enforcement officer, a deputy who has been accused of repeated acts of shoplifting, stealing groceries and kids' clothes from stores. Sheriff or deputy behaving badly in Florida. Let's read a little bit more about this. A Martin County Sheriff deputy is accused of stealing kids' clothes and groceries in Port St. Lucie. The sheriff's office has arrested Nelson Garcia, 40, on multiple counts of retail theft charges, otherwise known as shoplifting. Investigators say that he stole items from Walmart in Galton Boulevard in Port St. Lucie on 4 separate occasions, beginning on March the 1st. So, a repeated shoplifter. I have enough pain to say this without exaggeration. It feels like I've been stabbed in the back, and that's how I take it if one of my deputies did something like this, the sheriff said. According to the arrest report, each time after shopping at Walmart, Garcia walked up to the shelf checkout area with a cart full of items. Police say he would grab 2 items at a time, scan the first, and pretend to scan the second. So not a very sophisticated scam, but hey, I get one, you get one. I get one, you get one. Uh-huh. Police say on March 1st visit, he failed to scan a kid's multivitamins, toilet paper, Chip Ahoy cookies, Advil, Barbie doll, Skittles, nail polish, girl socks, girl t-shirts, cheese, and other items. So that seems like less like an innocent mistake and more like a deliberate action, right? If you fail to scan an item or maybe 2, maybe it's just because, you made a mistake. It happens. It happens to everybody. I don't know. It's probably, it probably has happened to everybody at some point. You can't hear me? That's just fantastic news. I hate my life. Thank you for letting me know. It's not my fault. It's not my fault. According to the arrest report, each time after shopping at Walmart, Garcia would walk up to the shelf checkout area with a cart full of items. Police say he would grab 2 items at a time, scan the first, and pretend to scan the second. So, not a very sophisticated scam. Use the self-checkout area, scan some items, but not scan others. And apparently, people started to notice. So he was taking a lot of things, apparently. Apparently, on one such occasion, on March 1st, which apparently was the first time that he's at least caught doing this. So far, the first time he was caught doing this, or the first time they've been able to document him doing this, he failed to scan a kid's multivitamin, toilet papers, Chip Ahoy, Advil, Barbie doll, Skittles, nail polish, girl socks, girl t-shirts, cheese, and other items. That's a lot of items. You know, if it was like an item, maybe it's a mistake. It happens. You know, people make a mistake. Sometimes they forget something, or, you know, they just make a mistake, but that's a lot of items. That shows a lot more deliberate attempt. Apparently, during that particular occasion, he paid $115, but also walked out with an additional $278 worth of items. So he's like, I'll pay you for 1 out of 3, apparently. Apparently this is the 67% off special over here for the sheriff's deputy. During a second trip in March 15th, he paid $97 and walked out with an additional $128. So only 1 for 1 on that occasion. So I guess he didn't want to steal as much. Sometimes 2 for 1, sometimes 1 for 1, but walking out with quite a bit of items. Police say that he made excuse me. Police say Garcia made another run on March 25th, paying $85 worth of items and failing to pay for $71. So at least he paid more than the things he stole. So hey, that's not so bad, right? He paid for the majority of it. So that counts, right? It's over 50%, right? So no harm, no foul? I don't think that's how that works. On April the 1st, police say that he paid $35 for groceries and walked out with $76 of additional stuff, which included strawberries, cake, green grapes, hamburger buns, Oreo cookies, backpacks, and other items. Investigators say he would scan a lesser value item while hiding a high price item before putting both items in a shopping bag. So yeah, just some casual shoplifting going on here in the Walmart. When investigators confronted him with video of the transactions, the deputy said, yeah, that's me. And if I didn't pay, I can go back and pay Walmart back. But really, for an egg that cost $2? Yeah, again, you know, if it was just one item, that's a mistake. People make mistakes. You should pay for the item. You know, it's not yours. But, you know, if it was just an item, it's a mistake. But it's a little bit more than that now, isn't it? So, yeah. According to the arrest report, Nelson told investigators, I wouldn't do that. Do you know what I do? While pointing at his patrol car. According to the arrest report, Garcia told investigators he was having computer issues at the scanner, and the Walmart lady came and helped him. When asked about $128 worth of unscanned merchandise, Garcia replied, come on, I work for the sheriff. The sheriff's office said he's on unpaid leave, pending investigation. He's facing an internal investigation by the sheriff's office as well. The sheriff says, like all deputies, of course, he's sworn to uphold the law. He was hired in 2018 and said, other than minor traffic accident, his record has been impeccable. This really surprises me. If convicted, I will absolutely fire him unequivocally. The sheriff's not sure what led him down this road. The sheriff says there are resources for deputies who struggle, and his salary is apparently $65,000 a year. Police say, of course, they have surveillance video showing him not scanning numerous items. So, you know, yeah. Plus, that brings us to the end of the story of the sheriff's deputy who stole a bunch of stuff from Walmart by scanning some things and not scanning other things, and apparently eventually got caught and said, I wouldn't do that, but apparently he totally did. So, yeah. So, I think that he's in a lot of trouble and is going to get convicted and fired. And that's, for the moment, brings us to the end of this story of Florida Man. And we're done. We are done. We've done our stories for today. I love you. I love you all. I love you, chat. You're the best, chat. The time for a song? It's always time for a song. I love my chat. I love you, chat. You're the best chat in the world. Love you, chat. You're the best chat in the world. I love you so much. Give you all hugs and stuff for me. Love you, chat. Best chat in the world to me and you and me. Love you, chat. Love you, chat. Any thoughts on Tucker? Not particularly. Nothing new to add on that issue. No, I talked about Tucker yesterday. Nothing particularly to do on there. So the record contract coming? Yeah, maybe. I love you, chat. You're the best, chat. I love you, chat. You're the best in the world. I love you, chat. Wonderful chat. Love to chat with me. What about the auto card guy that got convicted? I don't know about that one. Looking good, thank you. Feeling good. Shaved this morning. Trimmed my beard this morning. Got out the electric razor. And trimmed out the edges. Trimmed out everything. Oh, I'm using the beard cream now. So that might help. Oh, and I'm using a new toothpaste. So we'll see if it makes my teeth even whiter. Do this every day so you can monitor my teeth glow. No, it's not Manscaped. No, I was I have a Philips. I have a Philips trimmer. I have a Philips trimmer to trim, and then I have a Braun electric razor, like 700 series or whatever it's called, or 7,000 series or whatever it is, and then just went up and just took the electric razor and did as much as I could to get cleaned up and stuff. What's beard cream do? Softens the beard, and helps it not itch and stuff. It's like a conditioner. It's basically like conditioner for your beard, basically. Make it more lustrous. Or at least that's the idea. I don't know if it actually does that, but give it a shot. Yeah. I need to put in some now too as well. Any lady friends in the improv? There's one girl I'm interested in, but I doubt she's interested in me because she's quite a bit younger than me. So, and she's shown no interest in me thus far, which is disappointing. But, maybe. But no, probably not. I'm the old man of the group. Everyone is younger than me by quite a bit. Is the beard cream scented? As a matter of fact, yes, it is. It's sandalwood, which is always nice. So no real prospects in the improv group, but that's okay. I'm having fun anyway. You're quite a bit younger and may be interested. Excellent. Well, you know how to find me. Kurt at uncivillawllc.com. Send me a picture and a brief bio, and we'll go from there. Yeah. I might shave at some point. I vary with the beard and not beard. I'll probably shave at some point in the near future, but it's nice for the moment. Have I tried online dating? Oh, yeah, I've tried online dating. I can't get anywhere with online dating at all. Online dating I've found to be impossible, at least in my experience. Find it borderline impossible to get matches. When you do get matches, find it borderline impossible to have conversations. I find the entire thing incredibly frustrating. I've tried dating online many times. I'm trying Bumble now and Coffee Meets Bagel with no luck. And I've tried Hinge, and I was thinking about signing up for eHarmony, but eHarmony is expensive. I was thinking about that. Yeah. Will I do another speed dating? Oh yeah, I should do speed dating again. All right, I'm gonna sign off for now. Bit of a red flag. What's the red flag? That I have problems with online dating? I think a lot of guys do. Is that a red flag? I hope not. I think a lot of people are frustrated by online dating. I don't think it's just me. I hope that's not a red flag. You know. Yeah. And girls definitely have online dating issues for sure too. Yeah. Their issues are different, but they definitely have issues. Yeah. And women tend to be a lot pickier than men on the apps by far. The data from OKCupid was pretty revealing on that when OKCupid did data on that. It was really, really interesting. So like men, when they rate women, like on a scale of like 1 to 10, it's on a kind of a bell curve. It's slightly shifted, but it's on a curve. And women, not so much. Women like are very much more judgmental than men. Quit looking and you may find. That hasn't been my experience. And I'm not actually sure that's a good strategy, especially at 42. A friend had major stalking from online dating, 5 years of legal hell. Oh dear. That sucks. All right, I'm going to sign off for now. This has been fun. I might be online gaming or later or something. I'll talk to you guys. All right. Bye bye for now. Email me if you want. You know where to find me. I love you all.